Good evening and welcome to True Grit Crime. My name is Mama Libra Scales. I am your host. I was supposed to start like way earlier and I am so late. I'm so sorry. Um it's been a really long day and I forgot that I dropped my husband off at work like super early this morning. And so he had told me earlier, he's like, I'll be off work about 8. And I was like, okay. And then he called me and he's like, honey, it's 8 o'clock. And I'm like, I know you said you get off at 8 o'clock. And he's like, you have to come get me. And I was like, holy guacamole, I forgot to go get him. So I had to go get him. Sorry about that. But how are y'all doing today? You know, I hope that you guys have been having a blessed and beautiful day. So this morning also, today was supposed to be Mitch Westerman's hearing. That was supposed to go down at 1:30 today, but that didn't go down either. So that has been rescheduled until July 18th at 1:30 p.m. Um, again, as long as it's like going on, I still plan on attending um, the hearings for Westerman. Uh, by the time, well, before we get to Westerman this time now, because we're looking at Shane Meehan going to trial um, in June this month. I believe he goes like the 25th. Hey, Aaron, giving me a view now. You'll listen later. Okay, honey, I just got on, so you really haven't missed anything. Um, but it's good to see you, and I know you'll catch the replay. Um, so yeah, so then we've got Shane Meehan. Okay, let's see. I want to say his court date is on the 25th. I'm fitting to look it up. Um, so we have that going on. And of course, if anybody isn't familiar with Mr. Meehan is the guy that was arrested for throwing Molotov cocktails at the FBI building and fatally shooting Greg Farrisee. Hey, Louise. Hey, how are you doing tonight? I'm so glad to see you here. So yeah, so today was like a bust as far as the Westerman hearing goes, but that's okay. Um, like I said, the next hearing is on July July 18th. So we will be seeing how that is going to be going down. Mr. Meehan, let's see. It's got a long thing because that's been going on for like a long while. Okay, so Mr. Meehan's next session is going to be on June 28th at 1:30 p.m. So we will get a chance to like, because I'm going to hit that one too. Um, so it's kind of like everything going on now, just like Richard Allen and Mitchell Westerman so far. Shane Meehan's hearings have been rescheduled a lot as well. So, hey, Dark Arts by Adrian. Welcome. Welcome in. Welcome in. I'm so glad to see everybody coming in. So yeah, so there's that. And then yesterday, right, we had Gold issue her order that she wanted to issue. So I wanted to her denial. So I wanted us to come in here, go over that, kind of have like a little bit of a chit chat about everything. So I am going to get that ready, pulled up for us. So yeah, I mean, I just kind of was bummed out a little bit that the Mitchell Westerman hearing got, you know, the rescheduling going on. I thought that was crazy, but I know that at his last hearing, the judge kind of said that they were, wanting to kind of play it by ear. They wanted to find out what was going on in Delphi. And of course, nothing has really been moving and pushing except that, Mr. Westerman was deposed uh, in between his last hearing and between what's going on next. Hey, Spectrum of Thoughts, welcome. It's nice to see you. So yeah, so we got that going on. So I'm going to go ahead and I'm going to share my screen. And we can get this order for this recusal going on. So make sure. Okay, yeah, you guys can see that. So just know, like, if you make a comment right now, like I can't see the chat for a second. I'm gonna fix that real quick, actually. Put it on my phone, and then we will have that so I can see what you guys are saying. Okay, so state of Indiana, Carroll, County of Carroll versus Richard M. Allen, order of judgment of the court. The court has reviewed the defense's second verified motion to disqualify judge and request for findings of fact and conclusions of law. Upon denial of this request, if this court denies this request, filed May 17th, 2024. As Trial Rule 52 is not applicable in criminal cases, the defendant's request for finding of fact and conclusion of law is denied. Neely versus State 297 NE 2D 847 Indiana Appeals 1973. Davis versus State 642 NE 2D 987 Indiana Appeal 1994. The court, however, will address each of the defendant's allegations in this order. Defendant claims the court directed the Carroll County Sheriff to ignore a subpoena. The court directed an email to counsel counsel on June 14, 2023, regarding the witness refusing to cooperate with the service of the subpoena and demonstrating a willingness to fight the deputy attempting service. The court requested a report of the witness' refusal to cooperate and be transported for the scheduled hearing and forwarded that report to counsel when it was received. The decision by the deputy to leave without the witness was his and was not directed by the court, which is really interesting because Mr. Lesenby testified otherwise, that he was told to leave. But also, I think the thing that is really interesting about this and that people should remember is that when there's a subpoena from the court and they go to pick up an inmate, technically they're not supposed to leave without that inmate if they're subpoenaed to testify in court. So if they have to use force or whatever, they are supposed to take that person with them and transport them to that hearing. So it's really interesting that, the deputy was like, well, it wasn't interesting. It's pretty much laziness. I don't want to deal with it. I'm not going to deal with it, and now she's saying, I didn't tell the deputy to do that, but Lesenby had testified that he was in fact told to go ahead and go. Defendant claims the court engaged in ex parte communication with the Carroll County Sheriff regarding the defendant's housing, transportation, and safety during jury selection and trial, May 13th through 31st, 2024. These communications were administrative in nature and did not address any substantive issue. The communications were directed to where the defendant would be housed during the trial and who would be conducting transportation. The court did notify counsel where defendant would be housed during the trial, as he is still under the safekeeping order, in an email, but did not inform counsel of the communication, as nothing substantially was discussed. The court has set the defendant's motion to vacate safekeeping order for hearing, but was required to cancel the hearing upon the filing of this pending second verified motion to disqualify. Counsel claims the court invited the state to limit defendants' Sixth Amendment right to present a defense. The court has always required counsel in all criminal cases to follow the law relating to the third party perpetrators. The court reminded counsel of their obligation to follow the law in the court's email of April 28th, 2024. Counsel claimed the court has disparaged them and ruled on defense pleadings without hearings. The court's comments about counsel's performance were documented in the court's order of April 30th, 2024, regarding their handling of discovery materials. If pleadings on their face are not supported by the law or admissible evidence, judicial economy does not require a hearing. Allegations the court has treated the prosecution more favorably than the defense are unsupported by any admissible evidence provided by the defense at the March 18th, 2024 hearing. The court was notified on May 20th, 2024 of an inquiry by the Indiana State Police to the court reporter via email on May 9th, 2024, regarding ex parte communication received by the court from Gary Boudet, which was previously provided to all counsel. The court is unaware of the extent of any Indiana State Police investigation. Defendant blames the court for ex parte pleadings which were inadvertently directed to the prosecutor. The defense staff filed pleadings and marked them as confidential, apparently unaware that the confidential marking makes them available to the state but not the public. Hi, something to say. Welcome in. Hey, Chelsea, welcome in. This is interesting, and I'm gonna go ahead and read through this, and then I'll hit the points that I want to hit in this afterwards. Was this sentence referring to ISP, the court reporter? Oh, what is this sentence referring to ISP, the court reporter? Okay, I'll reread it. Okay, so the court was notified on May 20th, 2024 of an inquiry by the Indiana State Police to the court reporter via email on May 9th, 2024 regarding ex parte communication received by the court from Gary Boudet, which was previously provided to all counsel. An inquiry by the Indiana State Police to court reporter via email, okay, regarding ex parte communication received by the court from Gary Boudet. Yeah, okay, so that entails the messages that I believe Mr. Hennessy was referring to in the March 18th hearing while we were there. But nothing really came of that. Judge Gold did not, she didn't even bat an eye at that, and it was really interesting. The court is unaware of the extent of any Indiana State Police investigation. You're unaware of the extent. But you knew that it was being investigated, but you didn't really take it as deep to find out how far it was being investigated during the March 18th hearing. I wonder why they'd be asking about it in May. Well, I would suspect because, okay, so we went to that hearing March 18th for the contempt stuff. And then they were getting ready to depose officers and stuff. We do know Gary sent a letter to the judge. Goal sounds like now the ISP is interested in it. Yeah. So they could be looking into what's going on with that, because it is alleged that he was communicating with Nicholas McLeland, and exchanging information. So they could be investigating it, I suppose. I mean, if they're calling to inquire about it, that's interesting. Um, Defendant blames the court for ex parte pleadings, which were inadvertently directed to the prosecutor. The defense staff filed pleadings and marked them as confidential, apparently unaware that the confidential marking makes them available to the state but not the public. Council staff contacted this court's staff and were advised that the statewide Odyssey case management system, not DocsPop, as alleged in the pleading, has a distinct process for filing pleadings ex parte as opposed to confidential. Okay, so that was something that was actually kind of like touched upon during one of the hearings. I was just curious about Jody, the court reporter. Yeah, see, I heard a rumor, and I don't know if it's a substantiated rumor, but I have heard that like a plug is in the clerk's office that people are getting information from. Um, I mean, that's allegedly. I'm not saying that it is happening. I'm not saying that it's not happening, but there is some interesting things going on with that. And I think it's probably going to end up catching up to them sooner than they really think. Um, so as far as the docs pop pleading, blah, 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 for the ex parte order. Okay. So specifically in court, it was talked about, that Nick McLeland had accessed, the ex parte order, which obviously is only supposed to like be between the defense and the courts and all that stuff. And he was talking about, he didn't just read like one ex parte order, not just one, and it wasn't just like happenstance. Okay. I think that it's important to note that Mr. McLeland had actually talked about reading a couple of ex parte orders, and he knew they were ex parte orders. Like in a way, it was like I don't know, it was like a cocky way to like be like, that he knew he wasn't supposed to read them, you know what I mean? But then he was like, "Oh, I didn't realize, Your Honor, I didn't realize that it was a document, for the defense." But at the same time, I mean, you didn't do this just once, you did do this twice. And it was DocsPop, I believe, was the actual referred to program, because that's where all of these filings have been sent. And so there was a discussion about, excuse me, I want to say it was Rosie who had said, like, at first they had questions because they weren't familiar with DocsPop. DocsPop was not something that they normally use. This was something new. And he did mention that at first it was a little bit confusing about filing certain documents. Like there was a way to do it. He did mention that they were able to get something sent over. They were able to figure out the system on how to use it, and that they hadn't had a problem since. But I think that also falls in line where Nick was talking about the last hearing, how he wasn't sure how to file something under seal. So it could be that particular program, he's not sure how to file it, and maybe he needs the steps that were sent like to Brazi and Baldwin for their peeps to figure out how to use that particular thing. But it was DocsPop that they were referring to. And honestly, like, I'm not trying to be like funny, but DocsPop is a terrible program. It's a terrible program for them to use. For all of these filings and stuff. Like, it's so frustrating. I have the DocsPop login and all that other stuff, but half the time I end up just going like to different sources to get the documentation for the documents that dropped to where I'm going, because DocsPop to me is absolutely useless. It's useless. Let's see. Yes, people were wondering where Fig was getting his info from. Yeah. And there was talk about it from the court reporter. Yeah. So the rumor is that those two were communicating. Um and he, let's see. Chelsea said yes. Something to say. Dark Art said, Chelsea, do you think it's the court reporters? Chelsea, I don't know, she says. I think it's possible. Something to say said he was bragging about knowing something about something big was coming. Said he would be talking to the murder sheets about it. He has probably scrubbed all of that. I think I have screenshots somewhere. Yeah, there's it was actually like a lot longer than just like when he was talking about like big things are coming. Okay? Like yeah. This was like in the works for a long time. Like these networking and relationships have been in the works for a long time. Um yeah. So just know that. Um okay. Chelsea said clearly it's not a great system. Everyone is confused by it. Haha. Oh my gosh, like okay, so this is how like weird it is. Like DocsPop. It kind of like tries to gouge you too. So you only get like so many of the documents. You can only look at so many of the documents for free, um, like at a certain number. And then after you hit that max number, it requests that you pay for a upgraded version for you to get the rest of the documents. And I can't even find in there, like, I've been through like the e-filing sections, I've been all through, like, I can't even find where they're even putting the documents at. The most I can get is like that page, that lists like, um, like a summarization type thing of what's going on in the filing. That's all that I can ever find. I never can find any of the actual legal documents on there. It's crazy. Um, Something to say said DocsPop is very useless. I paid for it for a month, got nothing that my case doesn't provide. Exactly. I mean, I go to my case. Sometimes I'll go and I will get the documents off of like Reddit. I've got a couple other like different sources that I use that are absolutely awesome. But yeah, crazy. Chelsea says, honestly, even if the court reporter is being investigated, I don't trust ISP to do anything. They will find no problem. Oh my gosh. And that's the problem. Okay? Like if you see this blatantly happening in your face and you're not doing anything about it, that is a absolute problem. That's the problem. Um there's a lot of things that are going on that are questionable. Um and it's it stops. It's got to stop somewhere, and somebody's got to start doing something. Like, because this is just too much. It's way too much. Um, so let's see. Um, DocsPop has, as alleged in the pleadings, has a distinct process for filing pleadings ex parte as opposed to confidential. The court did email defense counsel a tutorial paper authored by JTAC explaining the process. Since that communication, defense counsel have had no issue with their staff properly filing ex parte pleadings. Accusations of violating rules on access to court records have been completely explained and dealt with, including by the Indiana Supreme Court in the first writ of mandamus filed by defendant. Counsel claimed their motions are treated differently than those motions filed by the state. The court has set hearings on pending motions, which have now been continued due to the filing of this motion to disqualify. Wow. What a nice way to gaslight somebody, right? When defendant files pleadings, the state is entitled to file a response. The court follows Trial Rule 6 regarding time and gives the state 20 days to respond. Defendant is also given 20 days to reply to the state's response. Once the issues are closed, if a hearing is required, one will be set. I mean, how many times have these pleadings been submitted, and these pleadings actually, like, reading through it does absolutely require hearings to be set, but no hearings are set? It just doesn't make very much sense to me. Like, I've never, ever, 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 ever seen this type of, like, fuckery in a courtroom in all of my life. Ever. I've watched, like, tons of trials. I mean, like, this is just not how it works. I don't understand. I just don't. And I think it's going to be really interesting, like, to see how this plays out later on down the line. And if they are, like, if ISP is getting along, like, getting involved, and they are investigating some of these people and some of these issues that have been going on regarding leaks. I mean, it may be slow moving for some of these people, but some of these people are going to be really, really mad at themselves at the end of the day when they have to come up with bail money, because it's so crazy, the things that are being done, the things that are being said, the things that are being moved. And it's been like a strategic game of chess for people involved. So also they try to play like they're fighting when they're really, for real, like, not fighting. So, like, it's what I like to call the game of deflection. Kind of like the game of deflection that the police have been playing when it comes to, like, destroying exculpatory evidence, while other things are going on and you're looking another way. So they're destroying evidence in one case, like, seriously, while everybody is at hearings, for the Supreme Court, they're, like, tearing down the house in Florida. And in my personal opinion, I don't think that house should ever have been torn down, because it was a piece of evidence. Nobody has been arrested. And that property should have stayed up until somebody was arrested and prosecuted for that crime, because, I mean, you tore it down. Did you even bother to take out exactly, like, crucial things that you needed out of there, or was it just unimportant to you? So that evidence can disappear too. And then you say, oh man, I lost it. Kind of like these recordings and stuff, like all of these interviews and everything. I still cannot fathom how in the world you record over 6 terabytes worth of data. That was a brand new system. It goes from maybe you left the switch on to maybe somebody didn't press a stop button to maybe somebody unplugged it. Like, can you please make up your mind and figure out what's going on? Because you guys are, like, all of you are telling different stories. You're all telling on each other in some form or fashion. I mean, hell, if you're going to commit corruption, at least do it the right way. You can't even keep your story straight. But the saddest part about it is that nobody is going to make you pay the piper. Like, you're not going to have to pay the Pied Piper for the things that you're doing, because you have protections, because you're in a position of power and you have protections from state laws that honestly were made supposed to be protecting the people, but people in power are using it to their own advantage. And it's disgusting. Just disgusting, in my opinion. So that's all I have to say about that. So obviously, we have following trial rule 6 regarding time. The state gives 20 days to respond. The defendant is also given 20 days to reply to the state's response. Once the issues are closed, if a hearing is required, one will be set, which we know that is not ever set. You have not, it's absolutely mind boggling, the filings that have been put forth. I mean, you're left sitting there at the end of some of these filings going, okay, we definitely need to have a hearing about this. And there's so much piling on top of it, on top of one another. And it's not being addressed that, like, it can be confusing whirlwind for people who are not on top of this, you know? Um, Same, Mama. It's an awful sight. Yeah. Something to say. Dark Art said, yeah, exactly. Brian Miss, hey, welcome in. The spectrum of thoughts, Chelsea, especially with ISP like Coleman and Carter. Chelsea said 100. Brian Miss said, wait, it was brand new, but it wasn't digital. Laugh out loud. Like, he said that this, Steve Mullins, okay, he was on the stand and he had testified that this system was fairly new. In fact, he installed the system himself. He didn't have a company come out and install it. None of that stuff. Let's not forget the fact that they can only recover the videos that were saved upon those hard drives with this special Chinese program. And they had to send it to somebody to fix this. And they said, well, they were able to extract the video, but the video had no sound. None of the videos had sound, but they were able to extract the video. I mean, I read lips. Maybe you could do it that way. I don't know, but that just it doesn't seem right to me. There's something wrong with that. There's something severely wrong with, okay, we have the video, but we have no audio at all whatsoever, right? And you've lost like 6 or 7 months worth of evidence, okay? And then not only have you lost that evidence, but then let's not forget that Brad Holder gets interviewed at the Logansport Police Department. And what happens? That interview is gone too. Like, that doesn't make you stop and like pause and question what in the world is going on. Why is it so hard for these people to keep a hold of evidence? Why? Well, what is it? Then you have the alleged rumors about, the crime scene, like collection of the crime scene evidence, like people putting evidence on top of their vehicles, driving off with it, evidence lost. Like, seriously? I mean, I don't even like, it makes me feel like nobody even like cared from the beginning. Like, nobody was planning for this to get as big as it got. Nobody was planning for this to be solved at all. And you just see it, even like with the Flora fires, it was like, yeah, it's a case. And then nobody kind of like really worked on it for a while, and now you have all of this stuff coming forward with all of this information about the fires, what happened at the property, people involved with appraisals, like all kinds of stuff. Like, the receipts are out there now. It's no longer just a rumor behind the scenes. Like, this stuff is out for real in the streets. So I think it's interesting to watch people's reactions. And I think it's just going to still be interesting to continue to watch the reactions, watch the words that they choose when they choose to speak and tell their story. It's just going to get even more interesting. So, yeah, I, I'm interested to see that on top of all of it. So let's see. Defendant asserts that the court ignored his request to set aside 2 weeks for the defense case while refusing to set time limits on the prosecution. On March 6, 2024, defendant filed a motion for speedy trial. The court granted that motion on March 7, 2024, and set the case for speedy trial, May 13th through the 31st, 2024. On April 30th, 2024, defendant filed a motion for a pretrial hearing, which the court set for hearing on May 7th, 2024. At no time prior to the May 7th, 2024 hearing did the defendant advise the court that 3 weeks for trial was inadequate. At no time prior to May 7th, 2024 did defendant indicate a belief that 3 additional weeks could be added to the trial without notice to the court, witnesses, and more importantly, without notice to the potential jurors. Okay, I have to say this because I disagree with this. It was pointed out to them in the filings in June, like that they needed at least 15 days. I remember reading that in at least one of the filings. I know that, I believe it was Criminality confirmed that last night from some transcripts that she had from June too, like when Bob and Allie and Michael were going over it on the channel. And also, I have to point out that at this last hearing, this May 7th hearing, Rosie did say, okay, this is not going to be enough time for trial. And she's like, well, when were you going to tell me this? And Rosie literally said to her, I let you know back in September, October, because he did let her know in September, October in those filings. But then I guess he also had let that be known in June as well, because it was September, October was a reminder, hey, remember, I'm going to need 2 week, 15 days for trial. And I remember always seeing that in the filings. So maybe she and she did say she wasn't even reading some of these filings. We know that she hasn't been reading these filings. Right. And again in April, he emailed her in April. You're right, Dark Arts. He emailed her again in April. So it's he keeps going back and he's they keep reminding her in the filings. I think that it was really smart because all of their points, they know that she's not reading the filings. So all of these points they're reiterating and regurgitating in these filings, kind of hey, a little reminder just to let you know, or in case you did not read the Frank's memorandum, here's this and this and this, just to kind of keep it on a tract, you know what I mean? So that it's she's not getting these filings and going, oh wait, I didn't read these other filings, I have no idea what's going on. There's really no excuse because they literally laid it out for her piece by piece, you know what I mean? So I can't believe that she would even say that in her filing. Honestly, I feel like that's perjury. Did you just perjure yourself in your own filing? Quite literally. And also she didn't call the defense or the prosecutor and say, hey guys, we're going to get trial set. How many days do you need? None of that. There's no communication. It was made clear at court that there's no, absolutely no communication, but in filings going on between the prosecution and the defense. The court isn't even communicating except in filings at that point. And then she said that she was tired of her personal emails ending up in filings, so that she would no longer be addressing her filings over the phone or through the email and stuff. Like if they had something that they needed to address from their fourth, she said that it would be brought to the courtroom and it would be addressed in the courtroom. So yeah, it's so crazy to me that, you know, it was reiterated in the filings several times. It is not anybody's fault that she did not take the time to stop and read the filings. And if she had read the filings, she would see that these things were addressed. Like they were telling her, like, hey, we need this amount of time. And then also, even just trying to work it out at the May 7th hearing, like I will reiterate, Rozzy did suggest to her that perhaps they would, after sending out 450 juror notices, okay, that out of those 450 people, because there was like a scheduled 625, I believe, was the total that was going out. Rozzy felt that maybe out of all of those obvious like juror summons and things that went out, that they would be able to find at least 16 able-bodied like individuals who would be willing to go the extra mile in their civic duty to, you know, sit on the jury of this case. And I think Rozzy was right in telling her, like, hey, like, I've never been in front of the judge before where there's like a start and an end date on a trial. Like, I've never seen a judge put a firm end date on a trial ever before. Kind of like, you know, you get in there and you go, but she was so firm about that specific amount of time. And when Judge Cole had asked Nick, like, hey, how many days are you going to need? And Nick says, I don't know, Judge. I don't know if I need 7. I don't know if I need 8. I don't know how long it's going to take me with witnesses on rebuttal. I mean, again, like, it's crazy to me. That's crazy to me because the specific question that Rozzy asked her was, Your Honor, the prosecution was talking about calling 115 witnesses to begin with. And the defense was going to call like 87. And he said, Your Honor, first and foremost, these 115 witnesses that are on this list, most of them are duplicates. It's just the same person with the same name on the same piece of paper. So, you know, Nick says, Judge, I think we can trim the fat down and I think we can get it to 45. Like, how are you going to trim the fat off of witnesses? Oh, yeah, that's right. If you duplicate the list, it's easy to trim the fat off to make yourself look good, right? Oh, man, I had 115 witnesses on this list, Judge, but, you know, I'm saving the court time and I want to get this done expeditiously. And I'm going to save the juror. I'm going to save the county some money, too. You know, I'm going to cut off those other witnesses. I can get it down to 45. You're really saving the county a lot of money, bro. You really are. I wouldn't even pay you. Anyway, so, but yeah, so Rozzy had specifically said, okay, like, we need the 15 days, you know, 87 witnesses is a lot. He said that they were afraid to file the witness list because they were afraid that it would be leaked. And I just, ugh, like, ugh. But he made it blatantly clear. And when Nick is like, well, I don't know how many days I need, he said, and this was specific, Rozzy asked Askell, Your Honor, are we going to get down to starting on the 13th and we get to the 29th, and on the 29th, Mr. McLeland is just now finishing the state's portion of the representation for trial. and you have a day or two left for the defense, and there's no time for any witnesses to really be brought in, whether it be experts or uh, witnesses to the case or anything like that. There would be no time to represent the case. And he said, we wouldn't have enough time to present our case. And I mean, in my opinion, I felt like Goal was kind of like offended by that. She was like, you can't wrap that up. You can't get that done. Like there was something wrong with him because he was concerned about his client receiving a fair trial and a fair shake, and he wanted to be sure that there was enough time for both sides to get through this, all of the witnesses, the trial, everything, so that it's a fair and just process. I just don't understand. Goal was very adamant about, listen, you're going to do it in this time. You can get it done. If you can't get it done, and when she backed them, because in my opinion, and I'm not taking the defense's side, I'm not taking the prosecution side, but in my opinion, she backed them into a corner for them to withdraw their motion to the speedy trial and to set this back out into October. That was like a way to bully. You tried to bully them off the case to begin with. The Supreme Court said, we ain't going to let you do that. You're wrong, wrong, wrong. And we are going to put them back on. You're going to act like an adult and you're going to do your job. And then it's like back to the childish antics. Like, oh, well, I'm just not going to read your filings. I'm not going to answer any hearings. Oh, you know what? You didn't tell me that you needed that time. What is wrong with you? What is wrong with you? You didn't tell me you needed that time for trial. She's making herself look dumb. Francis Goal, you are making yourself look unbelievably dumb and unprofessional by trying to act like you didn't know. Had you done your job and read these filings and scheduled the hearings that you said, that if the issues were required a set hearing that you would have set, which you did not do, we would not be here where we are today. And this is the opinion of as a citizen of the state of Indiana who pays their taxes and who would like for you to start doing the job that the state of Indiana is paying you to do. Please and thank you. Wish we could see your face mocking, laugh out loud, because he questioned her authority. Brian Amiss, yeah, he did question her authority, but, that's what you're supposed to do. That is what you're supposed to do. You are supposed to question the authority. You are supposed to ask questions. You are supposed to challenge. That's the point. That is the entire point of a trial, is to challenge the narrative. So, facts are facts. She does put them in those situations. Yes, she does. Think about where we could be if the Supreme Court had chosen to remove her back in January, right? We could be so much further along, so much further, the Franks motions would have probably already been addressed. All of these motions to suppress hearings would have been taken care of. This motion of admissibility would have been taken care of. The order, like the motion to address the safekeeping order, would have been taken care of. We probably would not have had witnesses that were subpoenaed to court that were supposed to be picked up by your transportation police, leaving people there. That probably would not have happened because another judge would have said, put that sucker in shackles, put them in a box, do what you got to do by any means necessary, because that is what the statute requires. That is what it requires. And if you don't believe me, look it up. Think about where we could be if the Supreme Court had chosen. Yep. Pattern of behavior becomes facts about her motive. Absolutely. And I mean, I know, like, excuse me, when I had went to the state Supreme Court hearings, you meet people that are there, and I met somebody who uh was there just to hear the hearings about gold, because she knows somebody who um had a case that was presided over by Goal. And from my understanding, there were a lot of alleged shenanigans going on in that situation as well. And it something's off. Like, if you have other people that aren't necessarily like familiar with the Delphi case coming in, and they are going to a state Supreme Court hearing simply because they have a friend or a family member um, that was affected by uh, the behaviors of this judge, that's something to kind of like perk your ears up and go, okay, like for real. That kind of makes you say, all right, well, there's an issue there. Like, somebody else, this is not the only case. Then you start to look into like people's past behaviors and past cases and things, and you start to learn a lot. You really do. So it's really important that you just explore and that you do your homework and that you understand exactly all of the things that you're dealing with, all of the players. It's really important. Um Sorry, I got off on a rant. Um so let's see. On April 30th, 2024, defendant filed a motion for a pretrial hearing, which the court set for hearing on May 7th. At no prior time to the May 7th hearing did the defense advise the court that 3 weeks for trial was inadequate. Oh my goodness, you lie, your feet stink. You don't love Jesus. Try again. At no time prior to May 7th, 2024, did defendant indicate a belief that 3 additional weeks could be added to the trial without notice to the court, witnesses, and more importantly, without notice to the potential jurors. Well, and here's the thing, guys. You also have to remember that as a juror, when you're called to serve your civic duty, you do not dictate to the court how long you will be there, like, and how that's going to go. Like, I was very surprised when she was like, well, we've already set the lodging, we've already set the transportation, and we've already told them that they will be gone from this time to this time. I'm sorry. Like, are you indicating that it's up to a juror how long their civic duty is going to last because you've already made them a promise that you couldn't fulfill in the first place? Yeah, that's a good question, right? Anyway, while the court agrees a continuance of the trial is harmful to the defendant and the state, it could have been avoided had counsel communicated prior to May 7th, 2024. And again, they communicated several times. Several times. Counsel they notified the court on or about October 4th, 2023, and that they would need 2 weeks to present a defense, but the court has no record of that communication, nor any recall of such communication. Counsel's assertion that between all defense counsel with the combined 70 years of experience, not one time have they been told a trial would absolutely end a certain day and not go any longer, is irrational and unreasonable. No, it's irrational and unreasonable to think that you can dictate how long a trial could last and take. You're supposed to present all of the evidence from the beginning to the end. It doesn't matter how many pieces are there and whatever else. You are supposed to present everything as a whole. People are not supposed to be withholding items of discovery from the other side. People are not supposed to be destroying evidence. People are not supposed to be doing. The only job that Judge Gold should have at this point is to be a mediator and to make sure that this is running smoothly. And I'm sorry, but she has been running this like an absolute train wreck. Absolute train wreck. The court is aware its colleagues across the state routinely give trial dates that begin on a set date and end on a set date. The court is not required to guarantee equal time for both the defendant and the state. The court is required to guarantee sufficient time on the calendar and sufficient notice to jurors and the parties to present their cases, however long it takes. Had counsel notified the court within days of receiving the March 7th, 2024 court order setting the case for speedy trial, May 13th through the 31st, 2024, that the time allotted on the calendar was insufficient, the court would have immediately rectified the situation and extended the trial to May 13th to June 14th, 2024. Okay, so I'm not understanding why, if you are willing to do that now in said filing, why you were unwilling to make that compromise and reschedule that while we were in court on May 7th, 2024. If you had those dates open, why? Why? And they did notify you. Again, they notified you so many times. Why didn't you go ahead and read the filings and take it under advisement? You know, I don't understand that. But I get it. You know, she's saying the calendar filled up fast for March 7th. But again, when they are sending you these pleadings and filings and you're not reading the filings, what are people supposed to do? You're not taking phone calls. You're not answering emails. You're kind of like tying their hands. Trial is now set for October 14th to the November 15th, 2024, as requested by the defendant. And I do want to say, like, okay, so when there was an order that was set for the speedy trial, if you go back and you look at that order, it's all about the language. There's very like specific, like telling language that like when you were reading this filing initially, you just knew that down the line there was going to be some fluffery along the way. True fluffery. Okay. The court is not required to guarantee equal time for both defendant and the state. The court is required to guarantee sufficient time on the calendar and sufficient notice to jurors and the parties to present their case, however long it takes. Had counsel notified the court within days of receiving the March 7, 2024 court order setting the case for speedy trial, May 13th to the 31st, 2024, the allotted time on the calendar was insufficient, the court would have immediately rectified the situation and extended the trial to May 13th to June 14th, 2024. Trial is now set for October 14th to November 15th, 2024, as requested by the defendant. Counsel accused the court of engaging in extrajudicial activity. Counsel is correct that on July 9th, 2023, the court commented on a Facebook post about a softball tournament her granddaughter participated in Delphi. The court did not attend the tournament, but did say congratulations to her former daughter-in-law's post about their team winning the tournament. If counsel's allegations in this part of their motion are well-founded regarding a potential witness' alleged social media activity and are presented to the court for ruling, the court will rule accordingly. Oh my goodness. Like, even if they were to submit it to you, I think that her answer would be, "It's irrelevant." That's what it would be. It would be irrelevant, is what she would say. Concerns about anticipatory rulings are not reasonable. They kind of are, though. Like, if you know that something is going to be an issue or could possibly be an issue later on down the road, wouldn't you want to mention said possible issue as early as possible so that it can be addressed? Um, do you remember what some of the semantics of the speedy trial that gave you pause? I will pull up the filing. It was just the way that it was worded. Um, like it was talking about like if there was any things that arose that were the defensive by default or by fault of the defense, that I would clear out the motion for like the speedy trial, like it would vacate it. Um, it was kind of like wording like that. It was really interesting. Like like I will go ahead and pull up the filing. Like I'll have to go back and find it. But when you read it, it's the wording that kind of gives you pause and makes you think like, okay, there is something that's going to be coming up with this. And it does kind of like tie in. It's just it's the way you have to pay attention to the words that are used in these filings. Like the way that something is worded matters a lot. It matters a lot, and it does affect something on a larger um note and perspective later on down the road, or to be perceived as such. Very interesting. Yeah. So, like I said, I can find that filing. I know I've got it, and I can find it and I can post it on the community page. Um so that you can kind of read it. And if you actually like sit and stop and read it and then you think about it, because I thought like when I read it, I was like, man, that's kind of like saying something's going to happen down the line. But then when like, I was just like, well, maybe nothing's going to happen because they did set the fast and speedy. You know what I mean? So, like, it gave me pause for a second while I was reading it. But then, like, I saw that the hearing for the fast and speedy trial was like set, and then, you see like it's like 60 days, it's like fast approaching. And so it kind of like gives people like, oh, okay, like, not really paying attention to that, like duty da, like everything's gonna be good. We're gonna get this going, like the ball's rolling. And then like now that you stop and like I go back and I look at that and I think about the pause that it gave me to begin with when I was reading it. I was like, dang, Um, Dark Art says, I think Baldwin and Rosie were afraid they'd get kicked off again. I mean, I'm not going to say that thought didn't cross my mind too. Like it was something that did cross my mind, and I was like, man, what if we go back to court and all this happens again, and there's a motion to, get rid of them again? Like, are we just going to keep like going in this vicious circle, all and around the mulberry bush, until something like finally collapses or falls or whatever? Or until like, what if this had gone all and around the mulberry bush so many times that it like literally exhausted Rosie and Baldwin to the point that they were finally like, okay, I don't know if I can deal with this anymore. You know what I mean? So, yeah, we'd all be going around the mulberry bush. But can you imagine, like, how long would it take for them to finally, like, get tuckered out from this constant, like, motion of craziness going on and finally say, okay, enough's enough, I back out? Or are they the type that's like ride or die and they're not going nowhere and they're going to stay right where they're at and they're going to try to tucker her out? And I think that that's what's happened. I think she really underestimated what would happen. So that's my opinion. I think that she was underestimating that this would get to where it got with the Supreme Court. I think that she felt like when she threw them out the first time and she was like, this is my house and this ain't going down like this, and you're not coming back here. Like, she was ready, like, to say, I rule the roost and they're not stepping back in this courtroom. That ain't happening, because she kind of made that snide little assertion when we went to court in Carroll County following that unexpected turn of events on the October 31st hearing. So, like, that next hearing, when Scremin and Librado was there, and Hennessy and Baldwin and Rozzi, like, all of that, like, it was like really like crazy. But it was like she kind of had that like snide little attitude, and like, they are not getting back in on this. Like, I don't care what they do, I don't care whatever. Like, right then and there, she had already decided that she had washed their hands of them, that they were gone from her courtroom, and she was hoping that the walking papers were going to stick, and then she'd move in these guys that like frequently come in to court before her all of the time. These are, Librado and Scremmins are two attorneys that she's very familiar with in her jurisdiction. So that was really interesting. It's like Bob says, so many defense attorneys are never exposed to a really potentially innocent man being railroaded. I would imagine not. You know what I mean? Like, I definitely take in account, like, some people are like, this is happening for a publicity stunt. And it could be. It could be happening for a publicity stunt. But I don't think that these attorneys are willing to put their necks on the line or their reputation just to defend somebody like that they are convinced, you know what I mean, is guilty in some form or fashion. Well, yes, because I'm glad they fought to get back the first time. Exactly. I'm glad that they fought too. I'm glad that they pointed out and said, hey, yo, no, this ain't going down like this. Because how many public defenders like would have just said, you know what? The state doesn't pay me enough to turn around and go back and deal with this. There's a lot of them that just would have threw their hands up and said, hey, man, better luck with the next set of counsel, and walked away from it. Because it is like such a, it's so crazy. It's so like convoluted in so many ways. You know what I mean? Spectrum said they could have easily let it go, but they fought to get it back in. Yes. Dark Arts by Adrian, they have real courage. They didn't need this headache. Exactly. And I remember like being in court, when Rozzi was talking about, he didn't have to deal with this. Like, he has a family at home. He has a practice. Like, he knows that like he could have turned and walked away from this at any given point in time, and he did not have to stand there and stay, and neither did Baldwin. They could have passed it on to Librado and Scremmins and not turned around again to even scoff at it. But the fact that they are going so hard, it strikes me. Like, it makes you think, like, again, as I said before, like, I don't know if Richard Allen is innocent or guilty, because we haven't seen all the evidence yet. Like, I don't know where I sit as far as that goes. I mean, as far as like I have seen, I don't, it's not 1,000 like 100%. Like, I'm not sure for that, man. Like, I'm not going to say from what is out there, from what I have seen so far, that I can 100% absolutely say I feel comfortable that this person committed this offense and that they're guilty. I can't say that because I haven't seen anything yet. But I'll definitely let you guys know, like, how I'm thinking along the way. Um, you know, because again, we have so much coming up, so much to see, that as things are presented in trial, like, people's thoughts and opinions are subject to change, you know? Um, Dark Art said, I don't think it can ever be 1,000%, but I feel like so much shady shit has happened. It has. It has. Hey Dan, what's up? Welcome. Welcome in. Um, yeah, definitely. And it's just so much. It's so convoluted. But like I said, I don't think that these guys would like take the time to put their reputation and their time, like their family is like on the line. You know what I mean? Like, a public defender really does not get paid a lot to defend people. You know what I mean? So I don't see them like, what did they make an hour? Like maybe $100 an hour or something like that, right? I'm not sure what their pay is. I know it's not like as much as it would be like private, like the private retainer type thing. But yeah, um, they take time away from their families, their lives. Like, there's a lot of work that has gone into this case. And then, like, just reading all of this, it's exhausting. It is exhausting. Could you imagine preparing for this case? I couldn't. Like, I would be like so like whew, overwhelmed because it is a lot. You know what I mean? Think about how many hours that they have to put into this. Chelsea or Dark Arts by Adrian says, yeah, $100. Yeah, it's $100. So Chelsea says Librato also said he believes RA is innocent. And that speaks volumes too, because if you think about, Baldwin and Rossi don't necessarily run into Librato and Scrummins, I would think not in any form, right? So like it is really interesting that Librato came forward and said, "Hey, like I really feel like this man is innocent." Like two sets of attorneys, well, I don't know cuz I don't think Scrummins has ever said anything, but Librato coming forward and saying something is really interesting. Yeah, compared to like $400 an hour, right? So they are taking a severe pay cut. I mean, there are other cases. And then think about it, like Rossi, he's one of the few attorneys in Indiana that is death penalty certified. You know what I mean? Like, and he doesn't just work on criminal cases, like some of these attorneys that are involved in stuff, they don't just do criminal cases, they work in family law and stuff too, you know um so but it's really interesting to see um like the how seasoned of an attorney Razi is like in his practice. To see the diversity in his practice is really refreshing in my opinion. um Dark Arts by Adrian says, I know at Chelsea and how haunted Librato looked like he was like gray. Yeah. Hennessy said $100 versus 400 plus. Right. So like, I don't know, like if I was, if I was a public defender and I had a case where I thought the guy was absolutely guilty, I mean, it's not worth the what is the, it's like not worth all of the craziness just for $100 an hour, is it? Like, I don't think that the exposure is like worth the $100 an hour if you really think that the guy that you're defending is guilty, right? You know what I mean? I don't know. Logic wouldn't tell me that somebody would go hard for somebody that they feel is guilty. That's just common sense. Um, so yeah, let's see. Defendant asserts the court has denied reasonable requests for funding. This is incorrect. Counsel is well aware of the amount of funds the court has authorized for the defendant. The court has requested the defendant to submit proper invoices and bills for Carroll County taxpayer funding. Invoices which have been submitted without appropriate documentation have been returned. The bill counsel refers to for $26,000 for investigative services from June 4th, 2023 through October 16th, 2023 was in fact returned to counsel as no documentation was provided for services. No documentation was submitted until quite recently. Without proper support and documentation, the court authorized that invoice for payment on May 17th, 2024. Yeah, but did you pay out all the money? Did you pay out all the money that you owe them for their investigative services? Or was it just a portion? Is what I have to wonder. So you paid them the $26,000 to, I mean, I would imagine that they would probably bill more, right? No documentation was submitted until recently. With proper support and documentation, the court authorized that invoice for payment on May 17th, 2024. Defendant complains that public confidence in this case has ended. As counsel should know, criminal cases are tried in a court of law, not in a court of public opinion. An independent judiciary requires that judges decide cases according to the law and facts, without regard to public clamor or fear of criticism. The court continues to receive ex parte communications from the public, criticizing the court both personally and professionally, and threatening the court with bodily harm and injury. That's really interesting. Because I don't know if anybody else remembers. Like, I don't remember ever reading a letter from a public individual claiming that they were going to bring bodily harm or injury to the judge. I have seen threats of like, and heard threats of bodily harm and injury being projected toward the defense attorneys and the defendant. I have not seen anybody go hard and talk about, I'm gonna do something to you, bodily harm and injury. I have seen letters of people telling you to go home and stay there. Don't even get up and come to work because you are embarrassing. I did see a letter pretty much that told you to do that. Which was really, really interesting. I mean, a 73-year-old man telling you to go home and sit down on the Davenport and don't get up, he means business. Okay? He means real business. Let's see. The court continues to provide these communications to the parties. The court is not interested in memes and other social media content that can easily be located on the internet. Paragraph 129 of defendant's second verified motion to disqualify. The court cannot be swayed by inappropriate and ridiculous outside influences. Defendant further claims the court has refused to order the state to comply with discovery rules. The court has set defendant's motion to compel and motion for sanctions for hearing, which has been continued due to the filing of this motion to disqualify. So again, like, you're gaslighting the defense after even all this time that these motions have been sitting in your docket that you haven't addressed them. It's really like, why gaslight them? Why not take personal responsibility and say, these filings have not been set, or these hearings have not been set for these filings because I did not read the filings and I chose not to set a hearing for them. I chose to allow these filings to sit on the docket and collect dust and cobwebs. It's crazy. Maybe 1,000 of us, right? Go home and stay, Fran. I mean, make history. That's crazy. I mean, I just am very, very frustrated with the choices that she's making. Like, I thought after the Supreme Court, like, gave their opinion and pretty much said, like, y'all need to just let this go and work it out as adults. I thought it wasn't like the Supreme Court just attacking any one person. It was kind of like, that firm but assertive, like, SWAT you get from a parent, like, saying, all right, man, get back on track. Not like hard, not like, don't leave a mark or none of that craziness, but you know what I'm saying. It's like when you were younger, an adult, I'm sure that somebody, like an adult in your life, gave you that redirection, so to speak. You know what I mean? Because it is, positive and negative reinforcement involved in many things. And I didn't take it necessarily as like a hard reinforcement, but I thought that it was a stern suggestion to get back on track. I thought that that would have been taken seriously, you know? Um, so the previous defense motion to compel was denied without hearing as it was unsupported by evidence. Defense counsel alleges bias by the court only allowing cameras in the courtroom on one occasion. The court has not allowed cameras in the Carroll Circuit Court due to its limited size and layout. Wow. The court did allow cameras in the Allen Superior Court at the hearing conducted on October 19th, 2023. The hearing was not conducted, and the media outlet providing pool coverage did not comply with the court's directives regarding coverage and broadcasting of the proceedings. The court lost confidence in the ability of the media to cover hearings appropriately. I'm sorry, I have to reread that again. The court has not allowed cameras in Carroll Circuit Court due to its limited size and layout. Okay. The courthouse in Carroll County, the courtroom specifically, it's not a huge courtroom. Okay. It's definitely not huge, but it's not so small that you could not get a camera in there. Okay. Like, you could have a camera in there with somebody sitting at the table to take care of all of that stuff. Yeah, the courtroom's a little bit smaller, but it's not so small that you could not get cameras in there for layout. So personally, I feel like that is just like one of the lamest excuses. If it's small, then you allow cameras, right? Because then that would deter people from like coming in and piling in there in large groups and things like that. Because, yeah, it's going to cause like this circus of people showing up, you know, trying to get a space in that room so that they could hear what's going on. Yeah, you would think that you would allow cameras. Also, um, I do have to reiterate it once again that Carroll County, the courtroom is small, but listen, the acoustics in there are terrible as well. Like, they're even worse in the Carroll County courtroom for the acoustics than they were in Fort Wayne. They definitely need to invest in microphones there if they're going to be doing this. Um, or if they have microphones, they need to be turning them on. But yeah, it would be much, much easier and much better uh, for the media to be in there so that they don't have a lot of people laid out in there. The court did not allow cameras in the Allen Superior Court at the hearing conducted on October 19th, 2023. The hearing was not conducted, and the media outlet providing pool coverage did not comply with the court's directives regarding coverage and broadcasting of the proceedings. I'm really interested in like what directives regarding the coverage were given to the news stations, such as I think it was Court TV that was in there covering. So, what did Court TV do that was against your advisement? Um, I think that would be something interesting to hear. Um, and you lost confidence in the ability of the media to cover the hearings appropriately. Could it be perhaps because of the way that you conducted yourself when the media was there last time that they had some questions, some things to say, some like was that was it too much for you to like deal with? Because I think that could be what it is. I mean, I think that maybe you might be getting your feelings hurt because people feel some type of way, or if something is said about you that, yeah, not everybody is going to be like nice, and they may not necessarily say something good about you. But I ask you something, is what Court TV says about you, about how you conduct yourself in regards to these hearings, is that going to matter to you 5-10 years down the road? Well, to a normal person, maybe it might, but to you, I'm sure it definitely would matter because you are running for an Indiana Supreme Court justice position, aren't you? I mean, if I was in that position, I would want to be as transparent as possible with the public. I really don't understand why this choice is being made when, you know, for a long time, Indiana was not a state that was allowed to um, stream trials and things of that nature. And it really surprises me that this would be her Judge Gould's view, because she was one of the 5 judges that was um, a part of the pilot program here in the state of Indiana to start allowing cameras back into the courtrooms to cover trials. And if you look it up, like the study and stuff about it, she talks about how she felt that cameras were something that was a positive for a courtroom. She felt that it was something that was positive that would be needed. I'm just wondering why you allowed the cameras into the courtroom and on this hearing that all of these unexpected turn of events happen, and then suddenly you get your feelings hurt and you lost faith in the media covering. I don't understand that. I thought you were all about truth and transparency, you know? I don't know. And I'm like I said, it's like nothing personal against her. It's just a question that pops into my mind. Um the court has issued adverse rulings against the defendant as well as against the state of Indiana. Adverse rulings do not support a reasonable basis for questioning the court's impartiality, nor are they grounds for disqualification. They are just adverse rulings. Defendant's second verified motion to disqualify judge and request for finding of fact and conclusions of law upon denial of this request. If the court denies, this request is denied. Wow. Dated May 31st, 2024. Wow. Holy guacamole, y'all. So, does anybody have any takeaways from that? Um, so Spectrum of Thoughts said maybe 1,000 of us writing Go Home and Stay Home, Fran. Make history. Dark Arts says Spectrum of Thoughts, yeah, why not just televise it? And Spectrum of Thoughts says because she's in the plan to sabotage the defense. Dark Arts said, yeah, Chief Justice Rush was like, be adults already, right? Exactly. And like one thing that I do like want to point out is like during the Supreme Court hearings, like when all of this stuff was going on and the arguments were being made and everything, like, you know, Rozzy and Baldwin really took those Supreme Court hearings like extremely seriously, like very seriously. And there were things that like Gold's attorney would say, and like Rozzy was sitting on the other side of the aisle from where I was at. Like he was like almost catacornered to me. And sometimes like when the attorney for Gold would talk, like Rozzy, you could tell he was so frustrated, but he would like shake his head no, and he would like put his hands to his head, like, oh my gosh, like seriously, is this like what I'm hearing? You know what I mean? Um, it just it's insane to me. It's insane. She doesn't want cameras. She's wants to wreck somebody else's reputation. Like, I don't get it. What is it that about these two attorneys that like you are very, very like irritated with? Because I've never seen her just like chillax and like cool with them ever. And I see her when I've seen her like interactions with the attorneys, it's almost like she gets very frustrated very easily with them. Spectrum of Thoughts that that's dumb as all get out. If it's small, then you allow cameras, right? You allow cameras in the courtroom. Dark Arts said, good call. Did she even give them anything to work with so she could be automatically upset? Yeah, I don't know, man. It just is crazy. Yeah, it is crazy. And I don't know cuz like I said, I've been to multiple hearings. So like I get it if people haven't been to a lot of hearings and stuff, you know what I mean? Or maybe they've just been to one hearing, so you've only got to kind of see that um interaction just that one time. But like even the hearing on May 7th, um you can cut the tension with a knife. Just how crazy it is like when she gets up on the stand. Cause like she was happy go lucky before the hearing. Like she was all like cool and like walking around, bebopping and cool. But as soon as she got on that bench, the whole shift of that attitude just, it was so fast. You know what I mean? And she's been like that every hearing, in my opinion. So, um, Rozzy is so spicy. He was very spicy this last hearing. And some people said, like, I guess maybe they felt like he was being rude. I don't think Rozzy was being so so much rude as I felt that Rozzy was being assertive and standing his ground, you know. Um Dude, that's what Nan said. She was super nice. Yeah, she was. She was walking around that courtroom, girl. She was bopping around. She had her little brown khaki pants on, her little maroon button-up shirt. She didn't have her judge's robe on. She was out there smiling, laughing with people, getting it. Like just happy-go-lucky. And when I saw her like that, I was like, wow, okay, maybe she okay. I can understand like being grumpy, you know what I mean? Like, and all that stuff. I can understand that. Um, Dealing with the cases sometimes I'm sure can't be something that's absolutely like easy for a judge at all times. But I at least thought by her pep in her step that like it was gonna be a good day. And it it didn't turn out that way. Like it just it's so hard to describe that instant shift, like that whole energy shift. It's really quite something to watch. The energy shift is very interesting. So, well, y'all, I've been on here an hour and 36 minutes. We made it through all the pages of the document. I hope that maybe something I said like struck your fancy, or maybe got you into the thought process about some things. As before, I always appreciate everybody who shows up, comes out, support. Um, if you like what you hear, please don't forget to like, share, subscribe. And again, just remember, like, I do like talking to my peeps in the comments section. Please feel free to leave comments. I do like to carry on the conversation. And with that, I will wish y'all a good night. Love, peace, and chicken grease.